Student confidentiality, maintaining your professional responsibility. In Kentucky, the Education Professional Standards Board is the certifying body for all certified school employees. They have outlined a code of ethics that rests on three pillars, including our ethical responsibilities to students, to parents, and to the education profession as a whole. One of the underlying tenets of these three areas of ethical responsibility is that of student confidentiality. Therefore, this presentation was created through the collaborative efforts of Warren County Public Schools and the Office of Professional Educator Services at WKU to outline our professional responsibility as well as policies and procedures related to maintaining student confidentiality, especially for those students who receive special education services. This presentation will address the needs of current and potential Warren County Public School employees, as well as WKU students who are completing field experiences, student teaching, or are engaged in other professional education activities within Warren County and in other school districts. It also provides insight into the responsibility of third-party entities in maintaining student confidentiality. Today's video will focus on 5 key areas. Those include specific definitions of confidentiality, educational records, and something called directory information, a review of the laws that guide our policies and procedures for maintaining student confidentiality, a closer look at exactly who may access student records that contain personally identifiable information, the process and documentation of inspection of those records, and we will conclude with a quick review of records retention and destruction as they relate to student records. Also included will be a quick guide for anyone reviewing or sharing student information in regard to who may have access, for what purpose, why that information may be requested, and where and how it's best to share that information. In general, confidentiality refers to one's duty to protect all personally identifiable data, information, and records collected, used, or maintained by the school district. This is a very broad definition in terms of confidentiality, so let's take a closer look at the term educational record. That would include anything the district collects, uses, or maintains relating to individual students, such as the permanent file, which may also be referred to as the school file or the student's cumulative folder. It would also include student or family names and addresses, the student's social security number, which has really been replaced in terms of school records with the SSID, the State Student Identification Number, through the Student Information System. However, there may be instances in which the school receives records that have the student's social security number, and that information must be safeguarded, of course. Grades, testing or academic assessment results, attendance data, discipline information, health and medical records, psychological assessment data, and teacher or counselor anecdotal notes may also be part of the educational record. Especially for students with an IEP or who receive speech-language services, this definition of educational record includes any file that contains their information, such as the cumulative file at the school level, a special education file within the special education classroom or department, and within individual classrooms, teachers' class or student files. It is key to remember that when parents request educational records, school staff are responsible for notifying parents of the location of all information, regardless of where that information may reside within the school setting. The information mentioned earlier that may be included as part of the educational record tended to be very formal and easily quantifiable. However, information that is not so formally identifiable or quantifiable may be also part of the educational record. Examples would include classroom data such as grades or work samples, correspondence containing student information, including email that is shared among or between staff members, discussions that may occur formally as part of a meeting to discuss student progress, or informally as student data is analyzed, as well as verbal comments and conversations, including phone conversations, which may occur within or beyond the school setting. It is important to note also that personal notes maintained by teachers, counselors, principals, or other school staff are not considered to be part of the educational record, as long as those notes are not shared. However, once a personal note is shared, it then becomes part of the official educational record and is subject to the same guidelines for confidentiality as all other educational records. Exempt from this inclusion of educational record is information that is often called directory information. This information must be formally identified by the school or district on an annual basis, usually in the student handbook, and it again is not subject to confidentiality requirements. When parents sign or return the student handbook form, they are in effect permitting the school or district to release that information without additional consent. Some typical directory information includes student name, address, and phone number, the date and place of birth, their major field or program of study, and any degrees that have been awarded, dates of attendance, classes in which they are enrolled, or the grade in school. Participation in official extracurricular activities, awards and honors, and post-high school plans may also be included in directory information, but again, it's only that information that is specifically identified and signed off on by the parent through the annual student handbook process or a similar process. It is important to note that if parents do not wish for directory information to be released, they must provide written notification to the school not to release the directory information. The laws outlining our responsibility in regard to student confidentiality at the federal level include FERPA, or the Family Education Rights and Privacy Act, IDEA, which again is federal legislation, the Individuals with Disabilities Education Act, and at the state level, the Kentucky Family Education Rights and Privacy Act. As a result of these laws, all school staff receive annual training in the area of student confidentiality, and specific school and district policies and procedures outline the responsibilities as well as the specific steps to safeguard that confidentiality. Finally, parents are provided a copy of their rights, including confidentiality, annually, often through the student handbook, and anytime there is a meeting or a gathering of individuals to discuss the student services plan or the individual education plan of students receiving speech or special education services, notice of parent rights, including confidentiality, are always shared with the parents participating in the meeting. Now that we have overviewed the specific laws and basic definitions in regard to student confidentiality, let's take a closer look at who may access educational records. These groups include school staff, parents and students when they obtain age 18, providers of contracted services who may not be part of the actual school system, and other third-party entities. It is key to remember that school staff must have a legitimate educational interest, what's often referred to as an educational need to know, in order to access student educational records of a particular student. Just because a staff member may be employed or assigned to a building containing students does not mean that that school staff member has a legitimate educational interest of every student in the building. They must be working with the student or have an other educational need to know the information to provide services or assistance to the student in some appropriate manner. So let's take a look at the school staff's role in maintaining student confidentiality. Every district has a specified individual responsible for maintaining confidentiality of student records. That is often the DPP, or Director of Pupil Personnel, or may also include or be assisted by the Special Education Director for the district. In Warren County Public Schools, a school staff list is maintained on each file cabinet containing personally identifiable student information to specify exactly who is authorized to access those records. District staff of another public school district may also receive that information upon the transfer of the student to that receiving district. It's important to note, however, that when students transfer to private schools, a separate written release is required from the parent before those records can be shared. Also, the U.S. and State Department may access records if conducting an official review of records or are conducting other official business within the district. Regardless, it is worth repeating that every staff member must have a legitimate educational concern or educational need to know to review a specific student record. Again, employees within a building do not automatically have access nor a legitimate educational need to know information on every student within the building. In regard to parent and student access, it is important to define the term parent. In regard to the rules and regulations related to student confidentiality, the term parent includes birth parent, legal guardians, a surrogate parent who may have been identified through a legal document, such as a power of attorney specifically for educational purposes, for example, or a foster parent. It's also important to note that regardless of their marital status, both parents have equal access to student records unless the school is provided with legal documentation stating otherwise. At age 18, students have legal access to their own records as well. School districts notify parents 1 year in advance of a student reaching the age of 18 to let them know of the impending transfer of rights from the parent to the student to review their records. Warren County Public Schools, upon the request of the parent, will then provide information relating to obtaining guardianship of those students who will turn 18, and that is a rather lengthy process, so the information is provided well in advance upon the parent's request. If a parent feels that a record should be revised because they feel it is inaccurate or not representative of their student, there is a process to follow to request that the record be changed. They first must submit a formal written request, and then Warren County Public Schools has 14 days to review that request and notify parents of the decision as to whether or not to amend or revise the record. If parents are not pleased with the response from the district, they may request a record amendment hearing. That review is completed by an objective party that does not have an interest in the outcome of the request. The determination is shared in writing with the parent within 14 days of completion of the actual hearing. And if parents still have a concern, they may add a statement to the student record if they do not agree with the outcome of the record amendment hearing process. When a school district contracts with third-party vendors to provide contracted services for students within the district, the same guidelines for confidentiality apply. Vendors are often under contract with the district to provide services such as occupational therapy, physical therapy, or other related services. These services may be provided through licensed individuals in any of those areas, for-profit service providers, or consultants available through an educational consortium, such as GREC in our area, the Green River Regional Educational Cooperative. Regardless of the source of the services being provided through contract with the district, those entities should have the same access to educational records as school staff. Similarly, those providers must have a legitimate educational concern or educational need to know to receive and review educational records so that they may provide the best services for the students. In addition, access to student records is also provided to the school board attorney when the individual is acting on behalf of the school board as their authorized agent in legal proceedings, such as when representing the district in a due process hearing. In some instances, the school district or staff may receive requests for student information from other third-party entities. This often involves the Department of Social Services or Child Protection Services because all school staff are required by law to report cases of suspected child abuse to the appropriate agency. When reviewing these reports and investigating as relevant to the student, any student records related to the suspected abuse may be disclosed without parental consent. Requests through court order or subpoena are honored after first demonstrating a reasonable effort to notify parents of the request. However, when requests come directly from law enforcement, such notification of parents is not required. Generally speaking, any other request other than those already discussed from third-party entities for student information containing personally identifiable information would require written release by the parent before such information can be released. When access is granted to student records to an individual beyond those listed on the file cabinet as having authorized access, there is a specific process to follow. This record of access includes documenting the date, time, what information was accessed, who accessed the information, and the reason for access, which we referred to earlier as legitimate educational interest or educational need to know. When others access the records, they are not required to be accompanied. However, parents will often request explanation from staff about particular information contained within the educational record. Copies of files may be provided, but parents or other entities may not receive the original file. Districts may charge a minimal fee for copying that information, but the fee must not in any way impede the parent's access to the file. Typically, Warren County Public Schools does not charge for copying student information. Assessment protocols are often a question in regard to student confidentiality because assessment protocols related to state assessment, psychological assessments, and other assessments that may be conducted with students are copyrighted. Those protocols may not be provided directly to parents or others making inquiries. However, staff may describe the protocols, including the types of items, discuss sample items, and provide general expectations of what students are expected to do during such assessments. Records retention and destruction is another important element of maintaining student confidentiality. Like all districts across the state of Kentucky, Warren County Public Schools follows Kentucky's record retention schedule for the timeline for specific retention and destruction of all school and student records. However, it's important to note that the district does maintain the following information indefinitely: name, address, phone number, attendance, classes completed, the grade level completed, and the year a degree was completed. In closing, this guide will help anyone make a wise decision in regard to student confidentiality. First, always ask who is requesting the student information, and does that person have an educational need to know or legitimate educational interest in the information. It's also important to remember who else may be listening or involved in such discussion and ensure that they also have an educational need to know. It's important to consider what information is being requested. Is that information protected as personally identifiable? Is it being requested for the legitimate educational concern? And information should never include opinions, hearsay, or other information that is not part of the educational record. It's important to consider why the information is being requested, how is it going to be used, and again, does it relate specifically to the educational concern or educational need to know. And lastly, where and how is this information being shared, especially in regard to verbal discussion or conversation? Is this transfer of information occurring in a confidential environment, even if the receiver has an educational need to know? Information should not be shared in a public setting, and we should always be aware of others who may be involved in or listening or overhearing such conversations. In closing, it's always wise to avoid providing personally identifiable student information if there is any uncertainty in regard to the who, what, why, or where of maintaining student records. The content for this presentation was based upon confidentiality for transportation personnel and other special topics of interest, IDEA and FERPA confidentiality provisions to the U.S. Department of Education, and KDE's procedural safeguards notice regarding student confidentiality. A special thanks is also extended to Karen Holland at the Warren County Public Schools and also to the Office of Professional Educator Services at Western Kentucky University.